Good morning. Thanks for being here bright and early. So I'm going to talk about why and how I believe that law schools should be teaching and using generative AI. And that's the theme for this conference. Hopefully, you're not too exhausted on the generative AI theme yet. So just a little bit about me. My name is David Kemp. My pronouns are he, him, his. I'm the managing editor of Oyez and Justia's Verdict. I'm also an adjunct lecturer at Rutgers Law School, where I teach a bunch of different courses: professional responsibility, critical legal analysis, which is an ASP class. I teach 1Ls sometimes, the 1L legal writing class, advanced legal writing, and then most recently, I'm teaching a class that the name has changed a few times, but I think I've settled on generative AI skills in law practice. So I want to start off by sort of acknowledging that there is a gap in the chain of ethical obligations from law students to lawyer. So lawyers, we sort of recognize that there are these obligations. We've got rules of professional conduct, there are court rules, or whatever the tribunal might be, client agreements. There are all these obligations that lawyers have. And we also recognize that there are obligations on law students as well. So there are the institutional academic integrity policies, but also to a large extent, the individual policies of a particular course or a professor. But law faculty, it's a little bit more amorphous, and I'm going to use sort of faculty and schools a little bit interchangeably here, even though I know they're not quite the same thing. But I was trying to discern what imposes the obligations on law faculty, on law schools. And I found, the American Association of Law Schools has a set of standards. The American Association of University Professors also has issued standards. The ABA, in terms of accreditation, is a source of some regulations. And then arguably the model rule or the rule of professional conduct 8.4 applies more broadly than just in the practice of law. And so to the extent that the faculty are licensed in various places, if they have that equivalent rule, those also impose certain obligations. But what I struggled with in looking at those obligations is that they don't really address this question of teaching or using generative AI in the classroom. And so I wanted to explore where is an obligation? Could we find an obligation to incorporate this both in the way we teach law students and also the substance of what we're teaching law students. So I looked around and I was wondering, is there another place that I could find a source of these obligations? And I thought perhaps there is, right? So physicians swear an oath to do good and avoid harm, right? These concepts of beneficence and non-maleficence. And what if we apply those to law schools and the law faculties that comprise them? So my arguments then is that law schools have both an ethical and a moral obligation to use generative AI if it can confer benefit to students and if non-use causes harm, and also to provide instruction on how to use generative AI effectively if proficiency can confer benefit and the lack of proficiency can cause harm. So taking a step back from that, I just anecdotally, there are a lot of different tools out there, as you know. This is just sort of a smattering of some of them that I know that my students have used or have tried using. ChatGPT is the obvious one. I describe it as both versatile and robust. It's a chatbot and document interpreter, which I think is one of the real strengths of that tool. Gemini, I do not describe as either versatile or robust for intentional reasons. But Claude is really excelling at a lot of the text tasks, and it does in documents interpretation as well. Microsoft Copilot, again, not so robust or versatile in my experience, also very slow. Perplexity, a lot of students I know are using Perplexity because it gives them more clear answers than just general search. Elicit is something that I've been using and I've been mentioning to some of my students who are working on scholarly work. It's a very helpful research assistant. It summarizes papers and asks answers if you've got sort of research questions and gives you summaries of papers that it finds. And then I've included because there's sort of the obvious ones for that are relevant to law students, Lexis AI and Thomson Reuters, Precision AI and CoCounsel, which are sort of separate products as I understand, but I have not seen anything other than a demo, so I can't really speak to them directly. And I also know that the students are not using that because at least at Rutgers, the students don't have access to those tools. They do to Lexis AI, but not to Thomson Reuters. So then I also have talked to my students and asked them how are they or how could they be using generative AI currently or in the near future? And some of these uses are good, and some of them are ones that we want to discourage. So summarizing cases and other long documents, we can envision that there are some good uses of this task and other uses that we want to discourage. To conduct legal research or assist with legal research. There, again, if they're using it as the research tool itself, not so effective, but there are other ways that it can supplement their research approach that can be an effective use of these tools. Writing is the big one, right? We're all concerned with how students are using it to replace their writing process or to supplement their writing process. And there are lots of different stages of the writing process, from brainstorming to proofreading and everything in between. And students are using it at various stages throughout that entire process, for better and for worse. Especially with the recent release of GPT-4o, it's especially helpful for things like preparing for oral argument, moot courts, mock trial negotiations, presentations, and so on, because it has that real-time ability to listen and speak in response. And then one of the ways that I'm encouraging my students across my classes to use generative AI is to assist with studying. So creating multiple choice questions in the specific style that they know they will be tested, either on, say, the MPRE or in a specific class, to come up with practice essays or practice essay questions so that they can engage in practice before taking the final exam. Outlining assistance is another way that generative AI can be helpful. And so studying is one area where I think students are not as readily using generative AI. And I think it's actually one that they can really benefit from its strengths. And then the last one, which is largely prohibited and largely discouraged in all contexts, is to assist with exam taking. I think we're sort of all on the same page with respect to that. So I'm going to briefly go through the risks because I recognize that they are risks, not to diminish these risks, but only to say that I want to focus on the potential benefits instead. But obviously there are concerns that use of generative AI could undermine educational objectives, risk over-reliance on these tools. Often the use of generative AI requires nuanced understanding or subject matter expertise, which our students don't yet have. The use could increase the risk of academic integrity violations if you allow it in some circumstances and not in other circumstances. Then that risks confusion to students, and so inadvertent or intentional academic integrity would be a concern. And then also, I think this is a pretty significant drawback, the lack of faculty who are either willing or knowledgeable enough to guide or supervise its use. We can't just turn students loose and say, now go use these tools. Inequity and access concerns, I think we've talked about that quite a bit, and those are real and valid concerns with generative AI. But I want to focus instead more on the risks of prohibiting it altogether or ignoring its existence, which some schools are unfortunately doing. So if a law school or faculty members ignore it or prohibit it altogether, the policies might be confusing or inadequate. And this free-for-all approach does actually risk exacerbating inequity. We've got students who are well-trained in technology, who may know how to get better and better, and we'll see the divide increase between those students and students who have less access to computers and support for using technology. Another significant risk, and one that we've talked about a lot, I think, at this conference, is that students will be ill-equipped for law practice, which is increasingly using generative AI in different ways. And students, we don't want our students to get out into the world, especially when our goal is to prepare them for practice, to get out into the world and not know how to use these tools or not know how to use them effectively, or to be in the news about being that lawyer who wrote a brief using ChatGPT and get sanctioned by the court. We don't want that to be our students. It's also just a missed opportunity to teach and use these novel and robust tools, these tools that really took the world by storm, and to ignore them or to prohibit them altogether seems to me a bit nearsighted and a missed opportunity to really engage with the students in a way that they're very curious about it. Some students also have legitimate uses for generative AI that an outright prohibition disregards. So some students are using it for legitimate accessibility reasons or for language assistance reasons. And so if we have a blanket policy that prohibits it or just disregards it, then we're handicapping those students. And then this risk that I think is one of the focuses of my talk today is that students will, if we don't teach them how to use it, they will use it and they'll use it incorrectly, they'll use it irresponsibly, or potentially and likely unethically as well, or in violation of academic integrity policies. And so rather than allowing that, rather than allowing this sort of free-for-all, we need to get in there and teach how to use it and also use it ourselves. So just looking sort of at the objectives, the benefits and goals of teaching using or teaching generative AI and actually using its use by the faculty. So if we promote understanding, if we promote student understanding and our own understanding, it helps students understand both the strengths and limitations of the technology, as opposed to the sort of free-for-all that I've described, where students have to figure it out on their own. And talking with students, I've found that if they don't really understand the technology, then they just assume that it's an answer-generating machine or a knowledge machine, and it really isn't. And the students who have a more robust understanding of how generative AI works are really well equipped to see what it's going to be good at and what it's not going to be as good at. One of the things that I just recently read this book, Co-Intelligence by Ethan Mollick, which is a phenomenal book. I highly recommend it. And this idea that generative AI should be a co-intelligence, not as a substitute for learning or for lawyering, right? So it helps students see how to augment their capacity, augment what they can do using generative AI, because it's a very powerful tool, as we all know, and we should help students, we should equip students to be able to use that tool. I mentioned curiosity earlier. I think that students are very curious about this tool or these tools and this technology, and we can foster that. We want students to be curious. We want them to be critical. We want them to be curious, and we want it can also help them develop a deeper and more thorough understanding of professional responsibility, which, as we know, is a critical part of the profession that they're about to enter. And so I think that using generative AI in the classroom and helping them understand it is a way of fostering that curiosity, of that critical thinking, and professional responsibility as well. One of the things that I have found in using generative AI, which I use on a daily basis, basically most, if not all of those tools on a daily basis, is that it helps me better understand the nature of the tasks that I'm doing. It helps me understand the tone, the audience, the structure, the format, and so on. And I think that would be really beneficial for students to also have that deeper understanding of the tasks that they're doing. I spend a lot of time when I'm teaching how to write a memo about tone and structure and word choice and diction and all that stuff. And for students to have a deeper or a different way of approaching that kind of understanding of what does it mean to produce this type of work product, I think generative AI could really facilitate that. And then this is sort of flipping a little bit and looking at the use by faculty of generative AI. But the benefit of faculty using that is that it really extends their reach. And as you know, whether you're in the academic support side of things, or if you're counseling students or mentoring students, your resources, your time are very limited. And you have a lot of students making lots of demands of you. And generative AI allows you to reach more students more effectively. I think used effectively, career counselors can use generative AI to reach more students and advise more students, more immediate help to students as well. Academic support programs as well could reach more students and give them more immediate feedback on writing and so on. So I think there are lots of different uses, and I'm going to demo a couple of those just to show you kind of what I envision these could look like. So a very wise man once said, If a machine can easily do everything we are asking our students to do, then we are not asking enough of our students. That was me. So the question then is, whose responsibility should it be to make these changes, to implement these changes at the law school level? And I really propose that it can't just be, I mean, I've been in meetings where people say, oh, it's the legal writing faculty because they don't have enough to do already, right? Or just the IT people, just the librarians. And I think that's misguided. I think that's incorrect. We need an interdisciplinary team. We need IT experts to help us understand and help convey sort of the tech background on how this works. Legal writing faculty certainly are integral to this effort, but can't do it alone. Doctrinal faculty, we need buy-in from the tenured professors, the clinical faculty as well, because what they're doing is really hands-on. They're in the dirt and they're using this technology, or they could be using it in conjunction with working with clients. And administrators, law librarians, like it's important that we all get buy-in, that we all be part of this process of integrating generative AI, both the instruction and its use in law schools. And some of the sort of alternative suggestions that have been thrown around, I think, are really largely insufficient. So I've heard some people say, oh, we should just have an information session. People can go have a free lunch, right? Give them pizza. That's really not enough. Although free pizza does draw in a large crowd. A single elective course is insufficient. That currently is what Rutgers is offering. I teach it, and I get about 20 students every time I teach it, 20 to 25 students, which is great, but that's a very small segment of the law school population, and that's not. I don't know that they're taking it because of the subject matter or because they've had me before, but that's just, I think the reach is not great enough just by a single elective course, or even just a couple of elective courses. This is a really important, I'm speaking to the choir, I know, but this is a really important thing that's going to be more and more pervasive in our practice, in law practice, and our students really need greater exposure and the signaling from the law school that this is really important and that they should pay attention to it. A link or like a page of links to resources, again, is just insufficient. It's not enough to show what the import of this technology. And I've read a lot about how professional responsibility is or should be incorporated into every course. I think most law schools fall short of that goal, but I think of AI instruction, generative AI use and instruction as very much like professional responsibility should be. They're very intertwined. And I think integrating them into all different courses is a really important part of really addressing this critical demand. So this is just a sort of a sample, it's sort of my syllabus for this class that I teach, broken down into sort of pieces. I start with just an explanation, a couple of days on what is generative AI, how does it work, because I believe that's so foundational for really understanding how it's going to excel and what its weaknesses are. And students who really have a deeper understanding of that tends to far exceed those students who don't have that deep understanding in terms of their ability to use the technology. Then a robust discussion of academic integrity, of ethics and organizational policies. So really focusing on how are institutions responding to this technology and how do we navigate those policies in a way that we can still use the technology but not run afoul of these different limitations or obligations that are imposed on us from various different places. The third module is examples of how generative AI is being used or can be used both in legal education and in law practice. So concrete examples showing them what it can do. I think that's really helpful for them to see what it can do, not just talk about it in the abstract. And then a module focusing on sort of the skill of prompt engineering, of task design. How do we break down our understanding of a task and then convey that to someone else? Because a big part of effective use of generative AI is effective communication, describing what it is that you're really looking for, right? And then the last part, or the last module here is actual use cases in law school and in law practice. So as you know, there are so many tools out there, and it would be really difficult. I know that some schools offer sort of a survey of different generative AI or AI products that are out there. As a lowly adjunct lecturer, I don't have access to most of those. And so I also think that that's more giving the students fish rather than teaching them to fish. And these products are going to be rapidly changing. They're going to be more and more of them, and then probably less and less of them, and then more and more. And so what we want to do, what I want to do is equip them to look at these tools and understand how they work, ask the critical questions about them, and decide, is this an effective tool for me to use in my practice, in my school? Or is it not? Is it just something shiny and new that someone's throwing at me and asking me to pay for, right? So equipping them to make those assessments on their own, I think is an important part, especially in this very rapidly changing area. And then for the final assessments, what I wanted was something that they can demonstrate that they've mastered each of these 5 different areas. So I want them to be able to demonstrate the ability to use generative AI tools for various tasks ethically, productively, and responsibly. And so things like making sure that they can effectively prompt and iterate with their questions, or re-prompting the tool, making sure that they know how to safeguard sensitive information or confidential information, and also reviewing the outputs, making sure that they've checked everything so that they're not just saying this is my final product without having really done the hard work in checking it. So a couple of other sample uses that I envision or have seen use custom GPTs. So this is one that is by Ken Norse, who works for the California State Bar. And it's, I'll just give you sort of part of the demo, but essentially what he's done here is it allows the students to ask questions about how to put together their resume or how to put together a cover letter or something like that, in a way that a career service office might not be able to do immediately when the student needs it, because they're working at 2 a.m. and they need that immediate feedback because they've got to submit this letter tomorrow or later in the day. And so this allows the reach of the career services office to really reach these students who need support right then. It really augments the capacity of these offices. What it's saying doesn't really matter. It's just more of a demonstration that I asked it a couple of different questions. What if I don't have any publications? How much does it matter what school I went to? And it provides pretty good answers to this. He wrote this several months ago, I believe, and I imagine that it could be even better now. But just sort of a proof of concepts that this is one way that career services could use generative AI to reach more students more effectively and more quickly. Another example would be in the academic support realm. So I wrote this custom GPT. So the idea is that a student could upload their syllabus from a particular course that they're struggling with or not struggling with yet, and ask questions about the content. So this one I just demoed. I uploaded a syllabus from an admin law class that I took back when I was in law school. I figured that the professor wouldn't mind since it's quite a long time ago, and then asking questions that I think I'll actually let you see this one a little bit more. This one that I asked for help understanding a concept, and then it suggested that they upload the syllabus from the course so that it could analyze it. It analyzes the syllabus. It tells me kind of what the topics it sees. And then I asked a follow-up question. I said, tell me about this sick chicken case that's one of the few things that I remember about admin law. So I asked, what is this sick chicken case? Can you explain it to me? And it understands what the sick chicken case is, and it gives me a summary of it, why it's important, and it also references sort of the other cases that have to do with non-delegation as well. And so that would be really helpful to a student who is trying to get this material and just is putting in the work and just can't, or struggling with it, for whatever reason, they're still struggling with it. And this allows academic support to be at the fingertips of the student, and can be written in a way that it doesn't give them answers, it doesn't create shortcuts for them, but it helps them process the material that they really need to get in order to do well, or even not do poorly on a final assessment. Here I even ask, I say, where was the sick chicken case in the reading? It refers to the syllabus and tells me what pages I should have found it on in the case book. And then some other questions that I asked here, what are some other non-delegation cases that I should be aware of? It lists some of them out, tells me where to find them. And then I say, how might this be tested on the final exam? So the GPT knows, or from looking at the syllabus, that the final exam is an essay exam, or maybe it knows that it's part essay, part multiple choice, and it says, here are some examples of multiple choice questions, here are some examples of essay questions that might test your knowledge of non-delegation. And so this is a really robust tool that students can, and I believe should be using to supplement what they're getting in class, because the professor, office hours, I think, are vastly underutilized, and I can't convince my students to go more. And I think that a chatbot would be more accessible to more students, especially when they feel that they can get immediate help without having other of their colleagues or peers be in the office and be critical of the questions that they're asking, or their lack of understanding. So I'll cut this video off. I just want to acknowledge that there are different perspectives on using generative AI as a tutor. So Saul Khan, who founded Khanmigo, claims that generative AI, a generative AI tutor can solve what's called the 2 sigma problem, identified by Bloom. So in other words, could provide every student with the benefit of one-on-one tutorial, which has been shown to improve performance by 2 standard deviations. And so that generative AI could solve this issue. In contrast, John Warner, who's a writing teacher and notable expert on teaching of writing, vehemently disagrees. In all of his tweets are in disagreement, actually. He's very, very vocal about it. He emphasizes the importance of human characteristics of tutors, such as empathy, humor, intention, compassion, and so on, and the harm of actually having continuous feedback on one's writing, that writing is an iterative process, and you have to continuously fail and get feedback on it rather than having continuous feedback. I think the answer lies somewhere in between here. I don't think that generative AI tutors are going to solve everything, all of our problems, all of our students' problems, but I'm not as pessimistic as Warner in thinking that we are trying to replace the humans. I still believe there's a really important role for the people, for the administrators, and so on to help students. I just think that generative AI can augment their reach and have them be a little bit more available to more students. So just to recap what I believe is sort of the role here is that law schools do have an ethical and a moral obligation to both use generative AI if it can confer benefits. So we've seen some benefits such as individualized feedback and individualized tutors, and if non-use causes harm. So the effects of under-resourced and understaffed academic support programs, student services, and so on can't reach certain students. That is a harm. That is a direct harm to students that could be avoided through the use of generative AI. And additionally, to provide instruction on how to use generative AI effectively. I didn't go into this as much because I think a lot more people have been talking about this as well. But learning how to use generative AI can confer a benefit to students, help them be more successful, both in law school and in law practice. And if the lack of proficiency causes harm, so perhaps it could exacerbate inequity and technological incompetence. Researchers have shown as recently as 2023 that the lowest performing students in law school classes significantly increased their performance with the use of GPT-4. And so it's sort of been considered as an equalizer in the legal profession. So thank you. And I guess, do I have a few minutes for questions? You want to talk? Yes.
Thank you so much. So this will demonstrate my very superficial understanding of how all of this works, but with your academic support demonstration, as well as with the career services demonstration, what universe was the genAI drawing from? Because otherwise, I'm wondering, is it something that's unique to that given law school, or is it just from the broad universe and everybody's getting the same answers?
So those were both written as custom GPTs. So when you create a custom GPT, you give specific instructions and you can upload documents as reference documents for sort of the knowledge base for the GPT. And so it's using the general knowledge of human language to interact, but in terms of the substance, it's largely drawing on things that the author of the GPT intended.
But it's all chat GPT, the open AI.
It is.
Yeah.
Yes.
Right.
Curious whether you're facing either active opposition to these ideas or complete indifference, and what would be better or worse for you in getting your ideas like throughout the school?
I am slowly getting a little bit of reception. I as an adjunct, I can't speak directly to what the faculty meetings are debating or anything like that. But I do know that Rutgers has asked me to speak to the faculty about coming up with policies about teaching them how generative AI works. So I view that as progress. I know that there is some pushback. I know that there's a lot of faculty who are going to say, absolutely not my class, or it doesn't have anything to do with me, not going to attend, and so on. But I think it's certainly a gradual process. And I think by demonstrating the ways it can be useful in various different courses, even things like torts or con law, I think would go a long way. If I could just get in front of a few people and show them, I think I could nudge a few people in the direction that I want. Yeah.
I can yell. How many times have you taught the course, and are you teaching it next fall?
So I've taught it once. I'm teaching it again this summer, and I'm teaching it again in the fall. Yeah. It's 2 credits.
So I'm a librarian, and my local chapter of AALL held what we called an AI shootout between products that we had access to. And so there was me and a couple of firm librarians using Lexis, and one of them sent our prompts and our outputs to a librarian who had access to Westlaw, which we didn't have access to. And that librarian said, oh no, your prompts are all wrong. It wouldn't work here. Here's what you need to do. And so my question to you is, given the lack of access to so many of these, particularly the legal specific generative AI tools, how in-depth can you really get in terms of teaching students when you don't know if the prompt that you enter in Lexis AI will work in Westlaw AI or Harvey AI, et cetera?
Absolutely. So I think that part of the skill that I'm hoping to teach students is that skill of creative thinking. It's like another way of teaching research. Of if this doesn't lead you anywhere, what went wrong? How can we approach the same problem in a different way? Right. So maybe it's not the specific prompt that you're using, but the way you're describing the task, and helping students to think creatively about problem solving is really sort of at its most fundamental level what I'm hoping to teach them. And I call it prompt engineering today. We might call it something different next week. But at core, I think what we're trying to teach them in all of our classes is critical thinking. How do I hit this roadblock and figure out what to do, how to go around it? And so regardless of which specific tool we're looking at, I think if we can teach them those lessons, then it doesn't matter what the tools are today, tomorrow, next week, because they have a more robust skill set to deal with those setbacks or obstacles. Thank you, everyone.
All right. So we're going to switch over to a kind of different universe now. We're going to look at a project called Wolf.
And we're going to look at how it ties together generative AI, legal research, and our goal. I'm from the University of Washington. My name is Jonathan Franklin. I'm a librarian. And I wouldn't be here without the help of all my colleagues. So thanks so much to everyone in IT and the library for letting me be able to work on this. But our goal at the University of Washington is to serve the public. During the pandemic, we had a challenge. How do you serve the public during a closed library? And more recently, as we've had changes, we want to reach out and reach other parts of the state as well. So one of the goals was to use technology. So I was very fortunate to be teaching a legal tech class right after ChatGPT in November of 2022. So we're going to talk about where are you on the hype curve, RAG, because I've heard a lot about it, but we're going to talk about it in a little more depth. Wolf, what is it actually? And then where we're headed. So the goal here is, this is all changing. I'm not putting myself forward as an expert. I am merely a guy who's been working on this stuff, and many of you will have better ideas or different ideas, and I welcome all of them. If you're feeling like there is no certainty, you are not alone, there is no certainty. But we know it's coming. We've already seen it integrated. If you go to Facebook or anywhere else, you're going to find it. If you want to see how things are changing really, really fast, you're welcome to go to the local llama subreddit, where there is exciting news every day, if not every hour. Eli showed the Gartner hype curve. I'll just say, you're at a different spot on here. Each of us is on a different spot on here. It's not as if the whole world is in the same place. So, I might be down here or maybe over here. You might still be up there. Marketing people will never come down from the peak. That's the reality. So we got to deal with it. So I'm going to show you a little bit about what Wolf is. This is Wolf in its infancy, but I kind of wanted to just give you a sense of sort of how we're looking at this issue. And I'm going to drag it over here. And I will explain why it looks the way it does through the course of this presentation. This is what it will look like. If I start a chat, right now, I have some text that will come up, right? Please ask anything you want. I'll try to answer it. There's a disclaimer, there's a scope note, all sorts of stuff like that. The disclaimer isn't here because of a variety of reasons. This is not publicly available. It will be ideally by the end of June because we're still embedding, and you'll know what that word means by the end of the session. More Washington State Supreme Court opinions, Washington Appellate Court opinions, and secondary sources. But if I ask, going to pick something very simple, cannabis law. You might think it's simple, but this is a great example for my purpose. So it's going through a workflow. If I want to do it in debugging mode, I can watch all the steps. There are many steps. So here's a little bit of a summary. So we have the RCW, we have medical uses, we have legalization, we have a bunch of other stuff. We also have some cases. We then have these citations, so you can go back to the information if you want to look at the raw source. Those are the chunks. And now what it's going to say is offer you some different directions for your next question. And no, we do not limit this to 10 subsequent questions. You can go to town. So this is the vision. The vision is something super simple that gives you concrete citations and that gives you a direction for the future of reading. Now, what you don't know is behind the scenes, when I typed that prompt in, there was actually a meta prompt and some stuff even behind that that is saying, respond in the language of the user, what the language the question's asked in, respond at the level of a high school student, because this is intended for the public, not for a lawyer. So there's a whole bunch of stuff going on behind the scenes to make this as friendly as possible. And it ideally will become friendlier and more accurate as we go on. So let's just talk. That's it for that. And anybody who wants to play with it, it'll be available soon. So what are the goals? Provide access to the public. It needs to be good, needs to be something that's responsible, that UW can have its brand on, but I can't make it perfect. I'm a guy sitting around with a couple CPUs and a laptop GPU in an office. The goal was to start with state primary law because state primary law here is broken up all over the place. We don't have a unified court system, so every county has their own courts. The legislature doesn't make it easy to scrape the primary law and a variety of other things. We'll talk about that in more detail later. The goal also here, thanks to the director, Carla, was to build library competence in generative AI. And I specifically said, well, you know, if we just sit on this and wait 6 months, there's probably going to be something really awesome out there. Are you sure you really want me to work on this? Because I kind of knew, it's not rocket science. And I got the okay to build something, even if it would be available off the shelf by the time it was done. That's pretty cool. And I thank everyone for that. So I got to do this. Now, hallucinations. We've heard a lot about hallucinations. I'm going to say that I really don't know what hallucinations are, and I'm starting to feel that everybody in the world has a different definition. So it started out being like quoting a fake case. Okay. Well, quoting a fake case is a bad thing, especially even though it's a mathematical process that generates the citation. So fine, citations that don't exist. But legal conclusions that are wrong, sins of omission, quoting a minority interpretation in a circuit split, quoting a dissent rather than a majority opinion, which of these are hallucinations? So does anybody have a sense for, let's say, legal conclusions that are wrong? Raise your hand if you think that's a hallucination. Okay, some folks. Minority interpretation of a circuit split. Okay, quoting a dissent. So how are we going to evaluate these systems? Yeah, the Stanford study's out there, but we need a new vocabulary because if some lawyers are going to be grumpy or some evaluator is going to be grumpy at those 3 examples, then we have to have a different word. We have to have either, you know, I don't know what, non-agreed upon, non-consensual interpretation. I don't know. That's terrible. Let's, pardon?
Unauthorized practice of law.
Unauthorized practice of law. Excellent. Well, so let's not assess these systems. Let's try to distinguish between fact and maybe opinion or arguability. Okay, so let's go on. What is going on with Wolf? All of these systems that we're talking about, that we've talked about, sit on large language models that are trained on far more than law, other than 273 Ventures. So if you're using ChatGPT or if you're using Llama 3, it was trained on everything from, you know, whether it was the New York Times to cartoons to Reddit to whatever. And it's really hard to get that out of the system. You're not really going to get that out of the system, right? So what we tried to do with this and with all sorts of other tools that you're hearing about, like Lexis and Westlaw, is, and many others, awesome systems, is retrieval augmented generation. Now, we've talked briefly about RAG, but the point about RAG is that it's only one way to minimize hallucinations, right? And what it does over here, this source over here, that is taking in legal content. So this is the statutes and cases of Washington in the case of Wolf. And then I convert it into a document type of a standardized document. Then I chunk it. Now you might say, well, okay, that's fine. Chunking it, all you're doing is breaking it apart. But I think we all know that if you chunk a statute, you're missing the part above it that says this does not apply when blah. Or when you chunk a case, you're chunking the dissent along with the majority. And so then you're possibly sending this incorrect chunk to the large language model, right? So you have to think about how you chunk and how you frame your documents. Now, then this whole process happens that I'm not going to try to explain because I barely understand it, but it converts it into a series of vectors, each of those chunks into a series of vectors, and it puts it into a database. That's all you need to know. It makes it into a set of numbers in a huge database that lets you go back and point to this chunk. That's what Wolf does. Wolf says, okay, you wanted to know about cannabis law? Let's go back to the chunks that mention cannabis law. I do blend full text searching and semantic searching, so it's not that simple, but I do, that's the basic idea, right? And then what it's gonna do is it's gonna spit out a result, and ideally these are gonna be the most relevant chunks of RAG. That's not all, okay? So here we have the documents, the chunks. They go in through an embedding model. We can talk about which embedding model, but there are tons of choices there, right? And then they go into the vector database. We just talked about that, okay? So that line there resembles what we were talking about in the last slide. But what happens with your question? I have a question about cannabis law. So what's going to happen is I'm going to ask my question, and it's going to go 2 places. And this is important. The first place it's going to go is my question has to be embedded the same way that the RAG was embedded. Because it then has to say, well, what are the chunks in the vector database that are similar to the question? So it takes the question, looks at the embedding model, sends that all to the vector database, then spits out the most relevant chunks. And that's awesome because you can ideally get good content this way. Then it all goes into the LLM model, which is, it could be ChatGPT, Llama 3, whatever you want. Then some magic happens here, and then we get our answer. Okay, so that's the basic process that we're using. And I think a lot of people are using architectures like this. So the benefit of RAG is not anything magical, and all it is trying to improve the prompt effectively by giving you relevant information before it ever gets to the model. Okay. Now, there are problems with RAG, and I don't want to sugarcoat them, so I'm just going to go over these briefly, because this is not rocket science, but everybody in marketing is saying RAG solves everything, right? Because it gives you the good stuff. Now, first of all, it's more resource intensive. Semantic search is not enough. So just that semantic search that I was doing is not enough. You need at least full text, and you maybe need natural language or other types of searches. And there are wonderful architectures now to combine multiple types of searches and the data from them to combine more relevant data to send to the large language model. So I don't think any one way is going to solve that. Second thing is a garbage prompt can lead to garbage results. We try our best behind the scenes to improve every prompt, but I know that the people using this are English maybe a second or a third language. It may be that the translation from Spanish to English isn't that great. It may be that they ask a one-line question, and I have to figure out, what are they asking? Are they asking about whether it's legal? Are they asking about whether it was a crime back in 1973? A bunch of other stuff like that. So chunking can remove relevant context. We talked about that. So how you chunk your RAG, and also I'll talk about briefly, I want to talk about overlap. When I talked about chunks before, I know I'm overusing that word, but anyway, it's kind of it's like the dollar. It's the currency of this process, if you think about it that way. You can have overlap. So let's say there are words that are really, really important in legal things, right? Well, maybe I don't want the chunks to just chop the document and have it end with one word and start with the other. I can actually make it so that it overlaps. So for example, I'll often have 10 to 15 characters of overlap so I don't miss a word. Effectively, the end of one section is also the start of the next section. And you can then get ideally better contextual pieces from doing that. So there are a lot of choices being made. Now, no matter what, I can give you the best content, but remember that large language models can mash up anything, right? So in Washington State, for a long time, cannabis was illegal. It was a crime. Now it's legal. So I take some chunks from the statutes that say cannabis is legal, and some cases from the era when cannabis was illegal and there was a criminal statute on the topic, and I send that all to the large language model. Just like your brain explodes, its brain explodes, right? What am I going to do with this fundamental inconsistency? There's a time difference, there's statutory difference, there might be appellate court decisions that are overturned by Supreme Court decisions. All of that might be perfect RAG, but the large language model might mash it up wrong. Whatever wrong is, I'll leave that to you. We're going to skip context windows, but I'll just say that memory of these systems is growing by the day, and so I think it's going to be irrelevant fairly soon how much it can remember. Now, let's talk a little bit more about RAG, and I promise we'll get on. First thing, so it can lose context. I might lack metadata, so it doesn't really know where it's from. So I've tried to add as much metadata to each chunk of RAG so that it knows the source of it. I've also preserved all the original documents so that if somebody wants to go back and recreate Wolf in some other new system, they will have all the raw materials to recreate it. And I think that's important as a librarian, is to preserve the original sources that you're using. We've talked about the mixing of statutes and cases. As you add more complexity to this, and we're going to talk a little bit about how we can add even more complexity, we're going to lose transparency. It's going to be really hard for people to understand in a couple years what this machine is doing because of agents and because I didn't hand do it all. Right now, I can explain what every word and why it's there within reason, but it's going to be increasingly hard to do because things are going to be happening behind the scenes dynamically rather than it being static. We don't have an integrated citator. So this is obvious. There are people working on this. I think we should all just throw money at Mike Listener right now because we need a citator. Because remember I was talking about RAG? What happens if that case was overruled? What case happens if that case was not good law? And I just cited a chunk of that case to a patron asking about something that matters to their nephew. That hurts me. But at the same time, the nuances, citators aren't black and white. Right? Because there's all this business about, oh, a caution symbol. Well, this section's okay, but that one isn't. How are we ever going to embed that type of data into these systems so that they retrieve the good chunks of a case, but not the bad chunks? So I'll say that that's a lifelong dream. Anyway, for a variety of reasons, we talked about statutes changing over time. Terms and meanings change over time. So somebody in a session yesterday was talking about infants. Infants as baby versus infant as minor, and how that word has changed over time to mean a different thing from what it meant when the law was written. If I use a word in RAG and I'm looking at cases from 1889 and 2020, I have a fundamental problem there. The word means a different thing because of the gap in time. Okay, so this is why RAG is not the solution, it makes it better. And I'm really happy with it, but I did think that when you listen to a pitch from a company, think about these things. Okay, great. Beyond that, RAG is interesting because of the way the question goes into the vector database that we already talked about, right? It comes out in saying these are the most relevant records. These are the 10 or 15 most relevant records. And what I've done is I've added in, and you can too, what's called a re-ranking model. And what the re-ranking model will do is it will take all the chunks of RAG and it will then optimize them to highlight what it thinks are the best of those by running it through another process, which is more computational energy, but it's not bad compared to an LLM. So there are three models we're talking about now, right? We have the large language model. We have the embedding model, how you embed the information to get it into the vector database. And then we have the re-ranking model. Each of these underneath it has about 10 or more variables that you can choose. So if you choose to tinker with this, you can have a lot of fun tinkering. Now, what is the goal for Wolf? The goal is primary law. And I have to ask, I have talked about this with several colleagues, the issue of what do we include as RAG? Should I be including the 1970 Revised Code of Washington? It was the law of Washington. It might be relevant. But is it going to mess up the retrieval more than it benefits the user? And I don't know the answer. I'm still grappling with that one. What do we want in here to provide the best possible results? If somebody has a case about a horse, we can't just say, well, only cases since 1960, because there's important law back there in the common law and in other cases from the state or even the territory. Okay? The next thing, cases. We're not going with the Supreme Court only. We're embedding all the content. Embedding is the process of chunking, sending it through the embedding model and storing it in a vector database. We now have 60,000 WASH cases to add. And I'll say that on my dinky little machines, that takes quite a while, partly because of the embedding model I chose. I can also do some really cool stuff behind the scenes to have it prioritize Washington second over Washington first if I want it to. So do we want to say prioritize recency, or do we want to prioritize, let's say, most semantic similarity? We have a choice to make. Now, how do we want to give the results to the user? Municipal codes are coming, secondary sources are coming, pathfinders are coming, Washington Law Help is coming, a bunch of other really cool projects in the future. Okay. Now, up till now, I could say you could do everything I've talked about with two tools that are kind of fun to play with. Okay. Anything LLM runs on Windows. It's being actively developed. You load your RAG, and you can ask it questions. Okay, another one that out of the UK is called it's.uk or .app.uk. They're in beta right now. Similar idea. You can tell from the layout, it's the same. So why didn't I use these? The reason is because I have a very specific vision, and you may all disagree with this vision, and that's fine, but I decided that I really liked it. First of all, I want this to be free and low cost. I want it to be free and low cost because what I'm doing for Washington, I want someone to be able to do for Oregon or Missouri. And I'm not sure that centralized tools are the best way to go for this because each state is so different. And I don't know anything about Pennsylvania and those side courts. So I leave it to someone in Pennsylvania who knows what they're talking about. So I want it to be exportable to other people. Open source is pretty clear. So everything I've shown you on here is open. We'll talk about that in a bit. No code. I start out using PyTorch and Python, and then I realized if I got hit by a bus, the thing would die. That's terrible. So what I'm trying to do now is I'm trying to use only no code, and I'm trying to create and document pathways that are making things clear for users and anybody who might follow me if they choose to continue it. We also wanted a local model. So, David covered a lot of whether it's Anthropic or OpenAI. I wanted everything to be on my box. I don't want somebody to shut down the embedding model. I don't want somebody to have control over my documents. And maybe I'm not paranoid, but I also wanted to be able to, for example, embed and retrieve reference memos from the last 20 years that has all sorts of information about faculty members. So everything that's happening is happening on those machines. There are no APIs going outside. I can unplug it from the internet if I want to, and everything will be fine. Compatible with our computing environment. I don't have admin rights for my computers, and that's fine. I just request when the latest Docker update comes, and I'm trying to minimize hallucinations. So now we're going to go to the public. What do we need to serve the public? Now, there are great articles on this topic, and I'm just going from my basic research and having read articles and being part of Self-Represented Litigants Network and a couple other things like that. People don't need much more than a chat box because everything they hit where there's a filling in something, especially if it's personally identifiable data, is going to scare folks away, and I don't want to do that. And I want everyone to use this tool. So the passion behind this is to make it as simple as possible and ask as little about the user as possible. I want it to be able to serve concurrent users. 70% of the users for Washington Law Help are on mobile devices. This has to be mobile first. I mean, it's fun that I'm giving a PowerPoint presentation about this, but really you should all be able to use it on your phone, and will be able to, because otherwise what's the point? Reading level, I have behind the scenes reading levels. So it is now pitched at high school. We'll see if I have some plans for some surveys coming up, and also trying to take into account language. Now, the embedding process, I used English language, re-ranking English. Large language model is going to be multilingual capable. So ideally, it will be able to take the English RAG and translate it using this detection of what the language of the question was. And finally, obviously, accessibility. We need to cover that. Okay. So I needed more than Dot or anything LLM, which are Windows. So I switched to Linux. It's running on a Windows box with Docker. I chose Diffie, but I'll talk about why I might be looking at something else. And then if you care, I'm using Olama now, but I have used local AI and Xinference. If you want to just go build this thing, you can. It really doesn't, it's not hard to do, which is great. I'm using Llama 3, 5.3, Mistral, and a couple other tools. for that, and re-rank is cohere if you care. Great. So now I have scraped. If you care about scraping, there's some great tools like ParseHub and Octoparse to go to the legislatures. And what happens in a legislature if you can't get a download is you can then have it pulled and docked into a database or spreadsheet, and that will retain the metadata. You can then use the metadata for the chunks of the RAG. So I did a lot of structured downloading rather than just taking like JSON or text. And so I did that thanks to obviously to the Case Law Access Project and to Free Law Project for both the APIs, the opening up of the bulk downloads, et cetera, et cetera. And the ability to break it into cases, which was key, because reporter volumes is not the way you want to chunk cases. So that's great. We talked about most of this stuff already. Covered that. If you want, you could start to pull in anything, right? So this is just the beginning. If I want to pull in Slack, Teams, Notion, our SharePoint website, anything. And I know that's scary in the context of copyright, but for free the law type things where I'm really just focused on text. And I know states have attempted to copyright certain aspects of their legislation. But anyway, so now let's say you have it all in RAG. What are we doing? Well, we're doing continuous modification to improve results. And what that means is changing the architectures around and starting to use agents, so like crew.ai, to look at how we can improve. Because everything I did, everything I've talked about for this whole 30-minute chunk can be done by an agent. It can figure out a better configuration of large language models in RAG probably than I can, as long as there are benchmarks on what goes in, what comes out, and we can evaluate the results and do A/B testing. There's a bunch of other things about that, such as the temperature of the LLM and results, and we could talk about that some other day. But anyway, continuous improvement. Spread the word. We got to get other people working on this. I can't do this myself, just like everyone else says, but we have to work together. There's a better tool I think that's coming, Lars, which a guy is working on. It's on GitHub. You can play with it now, but I just didn't want to flip over now. Agents are doing everything, and everything's going to be faster and cheaper. So that's cool. Here's how I want to stay. If you want to stay up to date, you can do some of this stuff. I think Ethan, Malik, and Sal Khan, I mean, it's kind of cool that David just shouted that out too. We didn't plan that. But I mean, they're kind of pop thought leaders. I don't know when they're going to jump the shark. So I don't think you should take anybody's advice blindly, but they're people that folks are talking about. Okay. So with that, I just want to thank everyone here who's shared their knowledge over the years. I've talked to many of you and gotten advice. And so thanks. Any questions?
Yeah, we have a question from someone watching online.
Sure.
It is, we aren't permitted to give legal advice to public patrons at our library, but Wolf seems like it could cross that line. Are there any concerns at UW about this?
Well, so I think the question is, and it's more general about generative AI and legal ethics and bar associations. So I think if you look at it pragmatically, kind of does this threaten the bar? Does this kind of a tool, which is just like an advanced law library with a cool search and a little bit of genAI sprinkled on top, is that legal practice? We've talked a lot about the sandwich idea, like use this at the start. This isn't the be all and end all. It doesn't include everything and it never will. So I don't think it serves as a lawyer would. It's a starting point. And I'm not even purporting to say that it writes well. So the only thing that I see this as a utility is giving you a crude starting point from which you can go to a law library or a lawyer and say, this is what I found, and I think this might be an issue, but I don't go file anything from this in court. There is a disclaimer that I have in the front top matter that you didn't see. And obviously we'll cover ourselves as best we can. Oh, here I can do that. Okay.
Yeah, just to follow up on that, giving answers to the public, do you think they're going to understand that this is just sort of suggestions? And Aren't there terms with both OpenAI and Google about legal stuff in particular that they don't want people using their products for providing legal answers? I mean, I'm just not sure how you guys are looking at that, because you're sort of
Yeah.
giving an answer, even if it's just a suggestion, with the words University of Washington on it, right?
Right.
So
That's definitely an issue, and I think that we have to cover. So first of all, I am not, even for this whole system, I'm not using any APIs that leave the building or the box. So I'm not using OpenAI or anything like that. I think that's an area that we have to work out. And if it's going to go to the AG before it becomes public, and if we can't get any CYA material, we'll figure something else out, or we'll call it a pilot, or I'll limit access, or maybe make it available to legal aid attorneys, but not to the public through some system. I mean, I definitely don't want to expose us to liability, but I feel like if every lawyer in the universe is going to have access to these tools, that if people can't figure out if they have a legal problem or not, then that's a problem in and of itself. And I don't think technology is the solution, but there currently aren't enough people to provide access to justice, attorneys, especially in legal deserts. And so the goal of technology is that maybe it can reach people who have cell phones, and maybe it can help more than it hurts. If it hurts more than it helps, then we just scrap the thing. Yeah.
Really quick question. So have you had a meeting with your general counsel of the university, or is there an unopened email about this project?
No, we haven't even gotten to that point, because I don't think that this is, I mean, I'll be candid, right? This isn't ready for prime time in any way, shape, or form. And the other thing, because the goalposts continue to move, as I work on this, all the technology is getting better, the results are getting better, and maybe even there will become some settled law or agreements between bar associations and legal information loosely defined providers that will make this either impossible, which I hope not, or more acceptable than being on the Wild West. But I think being a state school, we can't be on the bleeding edge. I can say that on a recording. Okay. Thanks so much.